Joining me now is University of California Davis law professor and an expert on the law and history around abortion, Mary Ziegler. Mary, thank you very much for being here with us. What's your expectation out of today?
Well, I think based on what we're hearing coming out of the hearing today, Judge Kaczmarek seemed pretty sympathetic to the plaintiffs, but aware of the fact that he would likely be doing something unprecedented if he calls on the FDA to withdraw this drug from the market. And he's unsure he has the authority to do that, which, is a valid concern, given that it seems the FDA has to follow certain protocols in withdrawing a drug from the market. It's not just something that a judge can command. So I think it's going to come in part down to questions of standing and also questions about whether this judge, no matter how unsympathetic he is to the idea of abortion or to this, what he perceives as the safety of mifepristone, whether he thinks he has the authority to do what the plaintiffs are asking him to do.
Well, let's talk about standing. How could he rule that the plaintiffs do have standing? What's the converse argument?
Well, the plaintiffs are arguing essentially that they have interest in the safety of their patients and that mifepristone is dangerous to their patients, and that unless the judge acts immediately, those patients will be in jeopardy. They argue that their standing as physicians and the standing of the medical profession as a whole is being damaged by the availability of mifepristone that's causing people to second guess the legitimacy of the medical profession. But I mean, if those things sound like a stretch, it's because they are. The only reason those arguments might work, I think, arguably is because they're before this judge, not because they're particularly strong
arguments. Do you have to present evidence of risk here? And if you've had this drug on the market for 20 years and as we understand it only has a 0.5 percentage point of women who experience complications, and as Laura just mentioned a moment ago, that Tylenol has more complications. Don't you have to present evidence that there is a risk here? And without that evidence, how do you rely on that legally?
Yeah, I mean, one of the things that's disturbing about this suit is that the evidence that the plaintiffs have isn't very good. And I mean, I think it's also significant to note that it was largely evidence that's been considered by the FDA already. So it's asking a federal judge who's not an expert in public health to rely on weak evidence to second guess public health authorities who are expert in public health. And that, of course, would set a precedent that could be used with respect to any number of other drugs, not just abortion drugs, but you could imagine anything from COVID vaccines to drugs used in gender affirming therapies to who knows what, cancer drugs.
Well, help me understand that. Why would it set a precedent for those drugs?
Well, I think it wouldn't directly set a precedent for those drugs, but it would suggest that there are judges to whom you can go and say, hey, we don't agree with the way the FDA interpreted this evidence, and we have this other evidence that isn't very good or isn't very sound that we're going to use to relitigate the question of whether that drug should be on the market. And you could imagine others who have problems with decisions made by the FDA on other therapies believing that the courthouse doors will be open to them.
There are other cases right now with women who say that they were denied care because the doctors refused to give them abortion, even when they're medically necessary, even when their lives were threatened, because doctors very fairly are nervous about what might happen to them. Is there any reason to believe that those cases might find their way to resolution on behalf of women who are trying to seek safe abortions because of their own health?
Yeah, I mean, we're expecting to see more and more of these kinds of cases. This one was filed by the Center for Reproductive Rights in Texas. We'll probably see others like it, pinpointing weaknesses in abortion exceptions, which are very vague. Sometimes in the case of Texas, contradictory. There, seems to be different exceptions in different bans in Texas law, all of which apply at the same time. And understandably, those ambiguities leave Texas doctors with their hands tied because they feel that if they make the wrong guess or the wrong interpretation, they can face up to life in prison for performing an abortion. I think the challenge going forward is going to be whether any exception, no matter how carefully drawn, really changes the dynamic, because doctors facing that degree of prison time are going to be reluctant to intervene if there's any ambiguity at all, no matter how slight. So I think these suits are really important, but the problem is bigger.